Yeah, so yeah, I did actually appeal this decision. So all these points that I've actually mentioned are all the points that was actually addressed in the appeal. But I just thought I'd just just give you a bit of understanding of how the court system is now compared to what it used to be. So if you are representing yourself, or like you're a new counsel, these are the kind of things that you've got to be really perfectionist about, and you find most lawyers are, or the top-notch lawyers, they cling on to, everything's got to be bang on 100% because they're after the truth, nothing but the truth. And that is exactly what a judge would be looking at, like if it was a jury trial case or something like that. They're looking for something that, they don't want nothing else, no in between. Everything has to be bang on. But even though my case is historical and the laws have changed, the laws have changed since some of the things that I've gone through, but it doesn't apply to my court case because those laws that existed at that time, they still apply to my case because it was at the time, in the moment of what had actually happened. Hi everyone, welcome back. Today's the last episode for the reserve judgment. So this is part 4. But before we get onto it, don't forget to subscribe and press like for support, and press the notification bell to let you know every time I upload. Yeah, so thanks for following me on my channel and for the comments and for the support. So I'll see you right at the end of this clip, and stay tuned. There's lots of good tips in this clip to help you gather evidence for yourself, or whether you got a lawyer or not. Regardless, you still need evidence if you want to pursue any kind of case. So yes, I'll see you at the end of this clip. Point 56. I record the plaintiff filed with the court on the 23rd of March 2017 a notice to submit further evidence and further affidavit by her, dated the same date. Included with these documents is a disc that is referred to as recording of the psychiatric interview with defendant 1, dated 4th of February 2016. I have not listened to the disc given this was filed after the hearing, and the defendants have not received a copy of this additional material. However, it would appear the plaintiff has in her possession sufficient information to draft an amended statement of claim. I'll pause here. Okay, I was a little bit like question mark over this paragraph, because she's written down that in regards to the 23rd of March notice to submit further evidence. Now, as I carry on with what she wrote, which I will soon, she's talking about the actual CD. But I did submit a CD of the actual oral assessment that I had with the first defendant, where my mum was there and another nurse known to defendant 1. But the request was made in advance to have this actual recording be heard in court. and this request was actually made on one of the orders that the judge got, and I'll come to that. It was so I just wanted to clarify the issues in regards to this portion of this paragraph here. The judge here has mentioned the 23rd of March that I lodged. She's talking about the CD here and the affidavit that came with it. The issue that I had with this was that this actual judgment that I'm reading was released on the 10th of March. So I'm not sure how that information was written on the judgment that was released on the 10th of March. So the issue I had was that she's written, she's confirming about seeing the notice to submit further evidence in the affidavit, which had the CD on it. But I know that I submitted one for her on the same day. I submitted the notice to have the case transferred to the criminal jurisdiction, which the one that I already mentioned in the last video, where I submitted it when the judge gave me until 5 o'clock the next day on the 28th of February. So I did submit a CD along with an affidavit on that day, and the best explanation I can talk about the 23rd of March was that because even though the councils knew that I was going to submit all that, and I actually wanted the actual CD to be heard inside court, all I can think of is I had submitted I've drafted up another one for the actual councils to go with the appeal. But I know I definitely gave a copy to the judge on the 28th of February 2017, and I actually told the registrar it was really urgent. And I felt I was in my right to actually, and I actually was legally in my right to submit this evidence, because it was already made an application in court and before court. So all the parties knew about it, judge knew about it, and so I just actually submitted the CD. But in saying that, the judge had already, and so the parties had already got the transcript that I wrote out from my phone of the actual oral recorded recording assessment with the first defendant. So I hope that makes sense. So the only explanation I can think of is that the 23rd of March notice of further evidence would be another sworn copy of originals, because everything I've given to the councils since this case was pending has always been originals, unless I've been advised otherwise by the courts. It kind of got, things sort of changed as time went on, but you know, you'll pick that up as we carry on with this court case. So there was an appeal that was lodged, so I know that I wanted to get the recording to the councils before the appeal date, but in saying that, the defendant number one, the one that did the oral mental health assessment on the 4th of February 2016, he had already submitted a transcript of the CD recording that I was trying to submit from, you know, as part of my evidence. But I actually wanted it to, you know, for everyone to listen to it in court. The plaintiff's list of documents relied on. So on this document has all the documentation that my civil case relied on. But defendant one had already submitted the same meeting, but he had a different date. He had the 10th of February 2016 on his transcript. So I actually made an application in one of the legal documents for the judge to ask him to, to retranscribe, because my recording and his recording, it just didn't, they weren't the same. So I wanted him to have it transcribed again. Going back to this CD and the affidavit that the judge is talking about that I submitted on the 23rd of March. So the application was actually made to have the CD heard in court, was made on that notice of objection for order to strike at the actual hearing on the 27th of February 2017. And there's a section there, and I will read the quotation from the actual legal document. It was a sworn interlocutory application. I will quote what I actually wrote on that document, so I'll be reading it. Evidence submitted, new evidence submitted. 1. Mental health assessment dated Thursday 4th of February 2016, transcribed by Minna Crichton from her phone mobile. 2. The recording of the meeting. The plaintiff would like to submit the recording of this meeting and would like to be heard in court as part of her evidence. And along with that was an affidavit of Minna Crichton. The request to submit further evidence with the actual CD was first noted on the interlocutory application dated 27th of February 2017. The application was called Notice of Objection for Order to Strike dated 27th 2nd 2017. Sorry, so there's a portion on this interlocutory application because it was actually sworn. On this actual interlocutory application, the evidence submitted was a new, there's a portion in there which clearly indicating what I wanted the judge to do. So it's written under the heading of evidence submitted. New evidence submitted. 1. Mental health assessment dated Thursday 4th of February 2016. So I had transcribed it from my phone. So keeping in mind, I've already got the psychiatrist's transcript, which I already mentioned in the last video. It was dated the 10th of February. So that should have already been on file. But what I'd gone and transcribed the actual meeting from my phone, the same one, and I submitted it as an exhibit with the CD. But when I saw it, the information wasn't exactly as what I had recorded. So I asked the judge if she could, get the defendant to submit, to give me another copy, because what he had didn't match what I had. There were a lot of, issues with the one that he had submitted. It wasn't exactly like what I had, and yet we both recorded the same meeting. Number 2, the recording of the meeting. The plaintiff would like to submit the recording of this meeting and would like it to be heard in court as part of her evidence. So I've actually made an application in this application to ask the judge, if she could listen to the recording. I actually had the recording on my phone, so I was prepared for the judge. I wanted her to listen to the recording, and I was hoping she would allow it for her to listen to the actual recording with the counsels in court. But she didn't bring it up in court, but she obviously read it, but it was noted. So that was the first time I made the application, and then the recording I gave after the actual hearing, and the counsels all got that too. And there was also a sworn affidavit because it became an exhibit. Conclusion of the facts and supported evidence is that the evidence, the defendants had no sufficient grounds to enforce or use the Mental Health Act Compulsory Assessment Treatment Act 1992 on the plaintiff. There has been serious miscarriage of justice, injustice, and abuse of authority, and the defendants have not acted on good faith. Costs. Point 57. At the hearing, I sought submission on costs. Mr. Watt. I don't know who Mr. Watt was because there wasn't a Mr. Watt at the hearing, so I'm not sure where Judge got that from. I don't know who Mr. Watt is. I've never met him because the only counsels that I've met in this case are the same counsels that I've been dealing with right through to the Supreme Court. So I don't know who Mr. Watt is or where Judge got Mr. Watt from. Maybe it's just an error. But she's written, Mr. Watt responsibly submitted that the defendants are not seeking an award of costs in accordance with rules and do seek a nominal amount in the event the plaintiff brings subsequent proceedings against the defendants. The plaintiff reminded me she is not legally aided and her finances are limited. Now pause there. The counsels applied to charge me for costs for causing stress on their clients. So the counsels made an application to the judge at the hearing on the 27th of February 2017 for the court to sue me or charge me for causing stress on their clients. So that I was shocked to actually hear that. I was really upset to actually hear that, but that's what happened at the actual hearing. And at the end, the judge actually she charged me $150 for each client, but they were actually going to charge me way more money. The counsels wanted to actually, because they wanted to, compensate their clients for stress, yet they're the defendants in this case. Point 58. I consider an award of the cost is appropriate. The plaintiff has been a court registrar working for the employer for a significant period of time. She will be well aware of the obligations upon the parties bringing proceedings before the court. I'll pause here. I did tell the judge a little bit about my background, so I knew exactly what I was talking about as far as the civil case is concerned and how they process. And there was nothing new to me, except now instead I'm not the registrar, I'm dealing with my own case. So because the judges knew, I never knew her before, and it was the first time I ever met her. I just wanted her to know that I do know what I'm talking about, and from past experiences, the applications that I was actually making to the court was legal by law, and I was within my right to have it transferred to the criminal jurisdiction and everything else that I actually applied for in court. So I did tell the judge a little bit about my background. The other thing that I found really demeaning to a woman or to anybody as like myself who don't have a mental health issue and very well of the system and very well aware of what is mental health problem, but the use of the Mental Health Act, basically nobody believed me because they've gone ahead and used it. But they've done it deliberately to defame me, and so they've put me through so much that, you know, everything has been deliberate. But that was sort of kind of the attitude I got from everybody because of the misuse of the Mental Health Act. So it was like, who does the judge believe? These prominent people with lots of money, and then there's me, myself. They looked down on me, basically. But it was a very difficult, I was determined to like, no, I'm not going to give up. What you guys have done to me is wrong. But yeah, but that's what I was up against in court because of the misuse of the Mental Health Act and how it was all done. They sent me out, and it's definitely a criminal case. But, you know, straight away, other people who don't know me automatically thinks that I've got a mental health issue when I absolutely don't. So I'll continue on with the judge's note. Further, she has not taken any appropriate action since the conferences on the 1st of November 2016, when Judge gave her quite a direct assistance as to how she could ensure these proceedings comply. Although the costs incurred by the defendants have been at the lower end of the scale, they have been incurred nonetheless. Counsels for the defendants has had to attend court on 2 occasions, and notices of protest have needed to be prepared and filed. Further, the plaintiff's copious documents have required evaluation. Point 59, an award of cost is appropriate. I have had regard to the plaintiff's limited finances and the benevolent position the defendants have adopted. The plaintiff is ordered to pay costs to each of the 3rd, 4th, and 5th defendants of $150 each. Criminal and civil jurisdiction. Point 60. More than once during the hearing and also before judge, the plaintiff stated she consented to the present proceedings being transferred to the criminal jurisdiction. I advised the plaintiff that I had no power to do so. The plaintiff has been given the opportunity to file submission. Yeah, she's talking about having the case transferred to the criminal, but it's actually already in the application that she has noted that she saw the order to strike, not to strike. At this point, none have been received. Point 61. The plaintiff also took issue with the transcript of the case management conferences from the 1st of November 2016. She submitted that, in fact, judge has been inaccurately reported. The plaintiff submitted that judge had informed her that the present proceedings could be transferred from the civil jurisdiction to the criminal jurisdiction. Point 62. The audio recording of the conference has been checked against the transcript. The transcript is correct where it records judge stating the following: I cannot transfer something to the criminal, all right? This is the civil court. The plaintiff: yes, I know that. Okay, I'll pause there. What had actually happened at the hearing on the 1st of November 2016, it was actually the first conference for this hearing. Now at this hearing, I made an application to actually have the case transferred to the criminal jurisdiction. So I made a formal oral application in court where the counsels were there. Also in this court hearing, there were other counsels in this hearing at that time, and I also took along 2 witnesses at the hearing as support, and that was my mother and one of my sisters. So I asked the judge at this hearing to have the case transferred to the criminal jurisdiction, and there was a little bit of communication going on. I was quite adamant that's what I wanted to do. The reason being I felt that right from the beginning that my case was being sabotaged. But in saying that, the judge, during the conversation in regards to getting the case transferred to the criminal jurisdiction, she did actually acknowledge in court that I was correct. But what I had to do was actually put it in writing, which I'm familiar with the court process. So I put it in writing in the interlocutory application that I've already disclosed in regards to the transcript. Point 63. The plaintiff's recollection is wrong and the transcript is correct. Point 64. In additional, there is no power to transfer civil proceedings to the criminal jurisdiction. Now here's another tip as far as the transcripts. Every single court case that everybody appears to is recorded. By law, it is recorded. Every single court, whether it's a list court, whether it's a status court, whether it's a family violence court, there's all kinds of names for different courts, but they are recorded. I'm also familiar in the old court system. I came from the Department of Courts when it was before it got changed to the Ministry of Justice. So before everything went technology, they used to have like a court reporter in the courts, and they would type every single word that everyone says in the courtroom, whether it be the counsels, whether it be the registrar, whether it be the judge, the plaintiff. Every single thing is recorded. But back in those days, the typists used to type everything. Everything was typed. The name for these people in court are actually called stenographers. So then they changed it to having people recording, like having through the mic system, and then they'll have the stenographers in another room, and then they would record what's been said in the courtroom. It is law that everything has said is accurate, 100, no errors. Everything that has been said, whether the person swears or the judge talks about the crime is, for example, sexual violation, every single detail that is being mentioned in a courtroom is all evidence. But it is vital that every single word is being said word for word, because a change of a sentence changes the direction or the meaning of what the actual person is talking about. So as part of your evidence in court, it is your right as the plaintiff or the defendant to have that transcript and make that application to have that transcript. So I actually applied for this transcript, but when I actually saw the transcript, it was a mess. There was a lot of errors. There was a lot of, a lot of this conversation had been left out. There were things in there that I didn't even recall saying, but it looked terrible. And because of what I was subject to, I knew I was being sabotaged, and I knew that, what was happening even with the recording was all part of what I was going through. So I actually put an application and asked the judge to if they could release the transcript, because I wanted this transcript for the next hearing as proof, that it was already confirmed in court, what judge had said to me and in the actual open hearing before counsels. But the issue that I had, the judge in the conference on the 1st of November 2016, she did allow that transcript to be released to me and to the parties if they wanted it. So but when I read the transcript, I wasn't happy with what I read, and it looked terrible. So that's why I made another application to have that transcript be retyped, because it's your right to. You can also ask for the recording of that transcript, because this is all legal, this is a court authority legal system, and everything in there has to be correct. Like every single word for word is what is recorded. Whether the person goes or cough or everything, it has to be absolutely 100% accurate. So I used to work doing depositions in a depositions court, so I'm from the old court system. But in saying that, the transcript that is being transcribed by the stenographers, they are, because now they've broken the system up. You've got to make complaints for every single thing now if something is not right. So that's exactly what they've done in this new system, where they've broken up everything. But the problem is, what they do now in this new system is everything is recorded, and then the stenographers are no longer on site. The stenographers are now like having access to the court hearings from different places around the country. So so they've like the whole system has changed. It's not like how it used to be. But in saying that, the recording for your court case has to be 100% accurate. And if you're not satisfied, you are within your right. The legislation allows us to make that request to have that. You can also have that information used in your court hearings if it goes to jury trial. Okay, so yeah, this is my court case, but there are lots of reasons why I've been a bit of a perfectionist, because it is my personal profile. I mean, it may seem small, at the time, or, one of those things you just, who cares? The problem is, if something goes wrong, when a formal investigation goes into, a case like myself, if anything happens, all this evidence that I've been trying to deal and sort out in court to get my personal profile correct is what the investigators, for example, the Serious Fraud Office or the FBI, these are the evidence that is all they have to go on. So I've been a bit of a perfectionist, knowing it's my personal profile. I'm the one walking this journey, nobody else. And so I've been, and I've also known legally, all these things will affect everything I do in the future. If I was to advance, for me to be able to advance and have a normal life. So that's the reason why I haven't given up on this court case, but I thought I would just explain around as far as the transcript is concerned.